morning, Your Honor. Amber Gibbs on behalf of the state.
Tony Chevron also on behalf of the state.
Please report on Mr. Puskas.
Thank you. All right, so we're before the court, continuing the motions, which we addressed in part at our last hearing, and we left off. Did we do the statements that we were intending to elicit or admit the statements during the jail call? Did we do those?
We didn't get there yet, Your Honor, and actually, we had just ended with the statements in the 4C. The previous setup that we had on January 14th was virtual, so at that time, the state did not play or have the capacity to play those actual statements for the court, just based on the setting. So just to end that segment and then to segue into the next segment, Your Honor, the state has prepared the redacted 4C statements that the state is intending to present to Your Honor for admission at the trial. I've also, for completeness, provided a copy of the 4C redacted statement to defense counsel as well as to the court to listen to at another time. But for the record, just so that it's completeness for that particular portion of the motion, the state wanted to include what portions were redacted. Again, the initial 4C clearly had the defendant as well as a second party, Mr. Wayne Stecker. That, based on the appellate division decision, was not appropriately presented in the first trial. So now the state just wants to complete that last motion with the actual statements that it's looking to introduce in the format that it will be looking to introduce.
Do you have it there with you?
Yes, I actually have it on my computer. I'm going to play it now for the court so that it's picked up.
I object to this. These are squarely out. It's not even debatable. And so in your discretion, you're bound by the appellate division decision, Judge. I don't think you should be entertaining this.
Your objection is good. I mean, I see what you're trying to do, and if it's not, it's out, it's out.
Right, Your Honor, and I understand that. What the state, the rule that the state is seeking to admit these under is statement as part of the claim. What we have here on the state display is the recording of the defendant's statements and to use them pursuant to the rule of statement as part of the vote.
But these are statements that you initially argued would be needed context, and now you say they don't.
Your Honor, during the previous trial, yes, the state argued that they needed context. However, the state believes, based on all the evidence that we're seeking to admit before Your Honor with the motions that have been filed, as well as the testimony that came at the previous trial, that in order to be in compliance with the appellate division decision, this is squarely within the realm of the evidence rules, as well as will still provide the information that's necessary to meet the state's burden. Again, the state statements are still relevant, truly relevant, based on the totality of all the other evidence that the state intends to present with their joint motions, as well as the evidence that is presented at trial prior. That was deemed admissible.
Thanks, Judge. Just on another issue that we dealt with last week, I don't know if you had an opportunity to look at the letter we submitted with the attachment right after the argument, because I know I referenced something that apparently was not submitted to you by the state, and when I referenced it in the argument, I realized it was never submitted. I don't know if you had an opportunity.
I have not seen that. Do you have that with you?
I have my copy.
Okay,
Sure,
so if
Judge.
you submitted it at some point, it'll be taken its way to my desk.
Yeah, I submitted it that day,
Okay.
and it has to do with Mr. Gordon. I was hoping to address that afterwards.
Okay.
So I'm going to play the portion. This first portion is going to come from the March 19, 2014 statement by the defendant. It was contained at approximately 10:53 p.m. I am going to say that that is going to be State Exhibit 2. And Your Honor, the state's going to start State Exhibit 2 at 6:42 minutes and ended at 7:23 seconds. And Your Honor, again, for the record, all statements contained on this disc are of the defendant. However, I'm moving to the portions that are relevant for this particular motion. Your Honor, I can hear it here, but I want to make sure, obviously, that the court hears it, so I'm going to try to move these.
How long you been approved?
It is mine.
I didn't even have anything with me. I smashed the mirrors off the phone call, and I was worried that people saw me when they came out of the house. No, I kicked them. They were fine. They were too pissed. I don't know. That was too much. I don't know. I was looking outside. I didn't want the clothes that could have possibly been seen them being in the house. I don't know. I was looking out. It was, I don't know. I need to get a little bit of just themselves out. A little bit of just put themselves out. But yeah, I just dropped it. I can't whatever you want to call it. I'm not a fucking cut. I can't do that apparently.
Now, Your Honor, those statements, again, were contained in our original transcript that was provided for the 4C. The state will provide, if the court would seek to admit these statements, would permit the admission of these statements, a full transcript of this particular disc. But what the state has done is taken out any statements made by any other party, specifically Wade Stecker. And these are only the statements of the defendant. The reason why these are relevant, as presented in the state's papers, on page 2 of the state's brief, it cites exactly where these statements were found. And for the record specifically, what the defendant is saying is, and this was read prior, Your Honor, I smashed mirrors off a couple of cars, and I was worried that people saw them when they came out the house. That was retrieved from the original transcript from page 12, lines 15 through 17. Then the next statement is, I gave them a fucking high kick boot. They were drop kicked. That was from page 12, line 22. I was bugging out because I didn't want clothes that I had, could possibly been seen being around. I don't know, I was bugging out. Dude, I don't know. I mean, it did get a little dirty, so that's from page 13, lines 3 through 6. And then they were a little dirty because I slipped and fell down. But yeah, I just drop kicked shit and it was nothing. I high kicked whatever the fuck you want to call it. I'm not a karate kid kung fu guy apparently. That's from page 13, line 7, 8, line 8 through 10. And that is from State Exhibit 1, the transcript of March 19, 2014, and it was from the time of 10:53 p.m. That was previously provided, Your Honor, in the state's submission. I'm only indicating that for the record to point, Your Honor, exactly to where the state is referencing this to. But again, that transcript, as well as those quotes out of that transcript, have been provided to Your Honor. What's been played today is how the state would intend to introduce that information as the defendant stating that those particular statements. Again, Your Honor, in the totality of the state's case, discussing that the defendant went out that evening and what happened when he went out that evening, the state submits that these statements are highly relative against whether or not the defendant went outside, A, and what he did when he went outside. The fact that the defendant states that he got dirty when he went outside is highly relevant to the state's case. That indicates that something happened where the defendant, quote unquote, slipped and fell down, where the defendant claims that he was kicking mirrors off of cars, and the state has evidence that on that particular night, there were no criminal mischief, no vandalism, no mirrors destroyed off of cars reported to the New Brunswick Police Department. All of this is highly relevant to the state's case, and all of this the state submits is admissible based on statement against party opponent rules of evidence.
And so you take the position that whatever questions were being asked of him in order to elicit those responses is not,
I take the position, Your Honor, that even if those statements are relevant, they do not meet the requirements for the confrontation clause, so the state's not permitted to use them.
I get that, but I guess my question was, because it seems to me that when you're offering somebody's words, that we need to understand the context in which those words were provided, and so now it's difficult to really follow the argument that where context was needed before, it's no longer needed. I'm not really following your argument there.
Your Honor, I believe that when the state has a case, they seek to admit all the evidence that they possibly can. Your Honor, while the context of those statements of Mr. Stepper asking, why did you go out that night, would be something that would add to the evidence here, Your Honor. The fact that those statements are missing is not, in this particular blurb that you heard, and I have a second one, Your Honor, but just to address the overall issue, is the other evidence that we have in the case. Meaning, it is clear here, based on the evidence, that we don't have anyone who is going to be able to say, Mr. Puskas went outside. We have people who said they heard him go outside. We have people saying they heard him come back inside. But we also are, the state's theory is that he went outside, and when he went outside, he committed this horrific offense. The fact that he is placing himself outside, while we don't have Wayne Stecker saying, where did you go that night? The state submits that based on Hassan Gordon saying, I heard him go out that evening, based on other witnesses saying that they heard him come back in, that will provide the context necessary to indicate why these statements are important. Because they sandwich in, someone said they heard him leave, he says himself that he was outside, what he was doing outside, and then someone else says that he came back in. And then it's the state's theory thereafter, Your Honor, to weave that all together in order to, again, provide the context necessary. So, in short, the state does not believe it is fatal that Wayne Stecker's questions of why or where did you go out, that it is fatal because those particular questions are not included in this particular statement.
Aside the issue that this has already been excluded, I just want to bring a couple of things to the state's attention. It's either Ms. Gibbs doesn't know the file really well, or she's attempting to mislead the court. I'm going to pick the form. I'm going to say she doesn't know the file really well. Danica Harpster observed Tim Puskas leave the house. Didn't hear him. She observed him leave the house. Okay? She testified to that. She provided statements to that. She didn't. She's not Gordon who says, I heard the old door open and the door closed. No. Danica Harpster provided direct testimony that Tim Puskas left the house. This, what the state's trying to do, Judge, is trying to convince the court to allow it that evidence. The state keeps saying, well, we want to present all the evidence because Mr. Puskas committed this horrific crime. And there's nothing, right? There's nothing. And the state, I guess the bell hasn't rung yet. Even after a 70-page appellate division opinion basically saying to the state, this is bad evidence that was let in, that there is no evidence, and maybe because there is no evidence, that this man is actually innocent. How does this come in? We can't just press play, right, on something in court, right? You have to have a witness. So let me just play this out for you a little bit. And think about the Bankston and Branch issues that are going to arise. Your lead investigator, who's Danowitz, is going to come in here. And there is no way, if you're going to meet the authentication rules of 901, 401, and ultimately 403, that you don't have to say, that the detective doesn't have to say that there was another person who was having a conversation with Mr. Puskas, and by the very nature of disclosing that other person who's a non-testifying witness, you're signaling to the jury that that other person had superior information. This is throughout the entire opinion about what happened here. And that's how, there's no other way around it. And additionally, Judge, Mr. Puskas, if we're to believe the state's theory of these statements, he is saying that he was out there smashing mirrors, right? That is a 404B issue. That's a 404B issue aside from 901, 401, 403. Now we're talking about an act that is criminal mischief, and it would have to be analyzed under 404B. There's no way this comes in, and the question you ask about context is the question. I mean, you play this, we don't even know what night he's talking about. Who's going to say it, right? The detective is going to have to say it's about this night. Because otherwise, how is it relevant? Right? Somebody has to say it's this night. So, and that person, in this particular instance, would have to be the detective. Because it can't be Wayne Stecker. And then, but the detective is recounting what Wayne Stecker said. And things that the detective knew at the time that are not permissible to go before the jury. This is, I can't believe we're still talking about this.
Your Honor, to answer that direct question, I'll start first with us giving context. First of all, the defendant gives context in the second statement that I was going to play. Detective Danowitz heard the defendant make a phone call. He heard him on a phone call. That's it. And defendant's words are on that phone call. It doesn't require any superior knowledge of the other person on the line or any inference to that. The fact is, Detective Danowitz on March 19, 2014 at 10:53 p.m. heard the defendant on a phone call make the following statements, and he can testify to that. However, I will specifically show where, without having Detective Danowitz testify to anything he heard or so forth, the defendant placing the context as to when he is discussing when he went outside. Then I will go back to the 404B issue as far as the smashing of the windows. Your Honor, this is going to be State Exhibit 3. It's the March 19, 2014 call. It's at 11:29 p.m. And that's State Exhibit 3. I am playing the portions that are from seconds 12 to seconds 19.
That was much earlier in the night. You know, I was well asleep by the time that happened with that kid. That has nothing to do with me, so stop. I know, because that was hours later. No, I was well asleep. Early. I went out like fucking 12. And that was like, 3 or 4. Yeah.
Your Honor, and now the State's playing portions minute 2:14 to 2:16. And with the defendant, again, just to specify for the record with the transcript of State, again, at page 2, lines 12 to 13, the defendant says, dude, that was much earlier in the night. You know, I was well asleep by the time that shit happened with the kid. Next is, I went out earlier. I went out at like fucking 12, and that was at fucking like 3 or 4. And then at the end, the portion from 2:14 to 2:16, it was I went out the front door. Again, Your Honor, the State submits that these statements here put into context the night that the quote-unquote shit happened to the kid is clearly the point of this case, that we are discussing his whereabouts on the night that this happened to the victim here, Billy McCall. So the defendant's own statements place in context what night he's talking about, what time he's talking about going outside, where we have video surveillance evidence, Your Honor, that will play at a later time, that will show, that will dispute the time he says he went out, again, indicating that consciousness of guilt of what he did, what he went out. And the state, again, based on the fact that these statements are his own statements, no one else's statements, nothing that Detective Daniels would have to testify to, except the fact that he heard the conversation at the times that are indicated on the date that is indicated. Other than that, the state's job would be to provide the additional information. Again, the video surveillance showing Mr. Puskas going out at a different time, showing the witnesses that come in and explain the fact that he went outside, the fact that he came in. What the state is here to prove, Your Honor, is what happened when he went outside. With his own words, he says he was outside, he got dirty, and now we get to the 404B issue about smashing mirrors. Your Honor, the state submits this was the defendant trying to give an excuse for why he was dirty. The reality is, the state submits, based on the evidence, he was dirty because he had bludgeoned to death the victim, Billy McCall, for the $40 to get back in order for him to buy narcotics off of Mr. Gordon. However, when Mr. Puskas discussed this, he made up an excuse and said that he went out smashing mirrors. Now, does the state agree that that could be a 404B issue? Yes, and we can go through that analysis. However, I believe that would be premature for the state to go through a 404B analysis without having a ruling as to the admissibility of the statements first. So that is why that rabbit hole did not go down. Again, the state agrees. If the statements are deemed to be admissible under statement against party opponent, then the state, for the small analysis of 404B, dealing with the Coalfield factors, we can go through why it's relevant material to the issue, we can go through the undue prejudice, because again, the state submits that based on the charges here, there's no undue prejudice with the particular statements about smashing mirrors. It's an excuse for why the defendant got dirty and came back dirty. So again, Your Honor, with that, I would submit.
You wouldn't argue that it's intrinsic evidence?
I would argue that it's intrinsic. I would argue that it's intrinsic to the entire case, that he's giving an excuse for why he was dirty, again, the consciousness of guilt. Yes, I would.
Judge, again, what night? What kid? Who gives context to that? We keep going back to the same thing. There is, just because a party makes a statement, it doesn't just come in. It has to be, first, it has to be some sort of an admission to some sort of guilt, if it were to even be considered. It's not, these are unequivocal denials. That's that. The other issue is, how do we know we're talking about the same night? Just because somebody says it was the night with the kid, what kid are we talking about? The issue, the Benston and Branch issue is not just, Danowitz not saying who he was talking to. It's what does the jury infer that is not being presented to them, that is illegal to be presented to them. I mean, that's what we're talking about here. Like, that was the entire first trial. That was the majority of the decision talked about, things that the detectives said, that it was about information they developed from people who didn't testify. The opinion is very clear that it doesn't have to be a detective saying, well, this person told me. It can be inferential. And that's the issue here. How do we get to these things? You're asking the jury to speculate without context. You're asking them to guess what night, what kid. The person could be talking about a completely different thing. So, and that's aside from the appellate division telling the trial court the thing is out.
Your Honor, I just want to briefly refer one moment on this. One, I want to make clear for the rule of statement against party opponent, it does not have, I need someone to show me in the evidence rule where it says it has to be about something that they're guilty of. The statement against party opponent rule states specifically that it's a statement offered against a party opponent and is the party opponent's own statement made either in an individual or in a representative capacity. While it should be relevant to the case, there is nowhere in this rule that it states that this statement has to infer some guilt, something wrong. in the statement as to the charges that are currently against that person. Only that it's relevant to the case. And Your Honor, the state submits that these statements are highly relevant for the reasons previously stated that I won't want to go back into, but clearly these statements are relevant to the state, proving that the defendant went outside, what he says happened when he went outside, and compiling that with the other evidence that the state has that contradicts it to show that actually the time he was outside was different than he says because he didn't want anyone to figure out that he got dirty when he went outside because he had killed Billy McCall. They're highly relevant, Your Honor. And I will also say that it does not require an inference that there was some superior knowledge by another person. This detective makes clear throughout his entire investigation that he was continuing to try to go through different suspects and individuals in this case. When he got to Mr. Puskas, Your Honor, the state again submits that he was privy to a phone call, and at that time these statements were made. It still requires the state to bring in different witnesses to testify, to be confronted, to explain the context that the state just stated to Your Honor, to sandwich in together the evidence that the state is seeking to submit with these statements. So again, there's no Bankston issue, there's no inference issue here. It is just a piece of evidence that the state's seeking to admit under the rules, and at this point, you have to sandwich it with the other evidence that has been deemed admissible on this case.
The rule cannot be taken outside of the rule book. And just because a person makes a statement, that means it's automatically admissible. It's governed by other areas of the rule, by authentication, by relevancy. If a person makes an unequivocal denial, if a defendant makes an unequivocal denial, that's not admissible in the case. Because it's not considered under the case law, and the case law interprets what a party opponent's statement is. It wouldn't be admissible because it's self-serving hearsay. So, if a person makes a statement that's not relevant to a case, and the state keeps saying, well, it's highly relevant, and I keep going back and saying, Judge, how does it become highly relevant without the testimony, without the illegal testimony? It doesn't. That's the issue. It doesn't become highly... The jury's going to be speculating how he got to this phone call. That's just one little issue out of a host that I've stated, and so many more I'm sure you can think of.
So let's move on to the request to admit statements made by the defendant during the
Do you want me to address the Hassani Gordon thing now, or do you want me to talk about that later?
So,
Just
I
brief.
don't know what it is,
So last time, I believe actually that the state had provided you, well, honestly, I wasn't expecting the state to argue, but the state argued that it's new evidence, and that's what Hassani Gordon was saying, that Puskas told him he was going out to get money. That was it. And then I didn't expect that, Judge, because the state, when they interviewed Hassani Gordon in trial prep, Hassani Gordon told them, and I quote, this is in a report, that they provided the defense. On the day of February 14, 2014, Gordon recalled that Puskas was sick and sweating due to withdrawal from drugs. Subsequently, Stecker provided Puskas with a sweatsuit. Gordon described how Puskas needed to get drugs and was desperate. Gordon recalls knowing that Puskas left that night because he went to the bathroom and Tim was not in the house. He thought he had gone to look for money based on something Wayne said. The state argued that it was new evidence that, Puskas told Gordon himself that he was going out to look for money. That was the issue last time, and that's why the state's saying, well, it's, we have a witness that Puskas said this to. That witness, in a statement to the detectives in preparation for trial, told the state that information came from Wayne Stecker, not from Puskas. But as I argued to you before, Gordon is the type of guy who has throughout this case taken things that were told to Stecker and told by Stecker to him and said, and changed and said, Tim said this to me. So the issue of Tim saying something to Gordon, that he was going out to look for money to buy drugs, is not a new issue, number one. Number two, it's hearsay based on what Stecker said to him, to Gordon. So, and I argued to you last time, Judge, it's not new evidence. It was ruled upon last time that the drug stuff doesn't come in because it had no connection to this case. And in the latest statement, Gordon obviously takes what Stecker said to him, that Tim went out looking for money, or that's what he believed he did, and attributed that to Tim. So, at a minimum, Judge, if you're gonna reverse the first court and allow this stuff in, at a minimum, you have to determine where that information came from. If it in fact, according to everything I have so far, except for that last statement, it came from Wayne Stecker, then it's hearsay. Then it can't come in. We're back in the same boat of information that's from outside parties. And now he's saying it came from Puskas. You're going to have to determine which one of those versions is accurate, Judge. Unfortunately, it falls to you because if it is in fact hearsay, I can't cross him on it because I'd be violent. I would have to basically elicit that some third person who's not testifying told him this to impeach his credibility. And we wrote a short letter for you about this very issue on January 14th. I hope.
I'm sure my law clerk will get it.
Yeah.
So the question I have for you is, to the extent that Gordon has provided a statement now, recently, that indicates that he received this information, isn't it ultimately up to the jury to determine the issue of whether or not he did in fact? Couldn't you ask him, well, did you really get that information or did you hear it from someone else? I mean, he's saying ultimately that it was given to him.
But no, I can't do that because then I would be bringing in what I'm being objected to, which is the fact that Stecker said this information to him. It's hearsay, and I can't confront Stecker about it. So that's why there's a threshold determination about any piece of evidence, Judge. Just because he says it now doesn't make it true. If he said for the last 6 times, I know this from Stecker, and every time he talks about Stecker, you will hear him in his statements, or you will read about him, or you may hear him here when he testifies. He gets upset because Stecker is dead. He gets upset. And for the past 6 times he says, Stecker told me this, Stecker told me this, Stecker told me this. And then now we have a reversal, we have to have a new trial, and then all of a sudden it wasn't Stecker who told me this, it was Puskas. That's a determination you have to make. And that's the issue with this evidence that now the state's saying is new. It's not new. It's always been known. It was presented to Judge Nieves, and at least back then, the state indicated that, Gordon says he got this stuff from Stecker. We can't use it. This stuff was not new. So if you're going to let this stuff before the jury, I think at a minimum, you have to determine what's hearsay and what's not.
Your Honor, I'll be very brief. One, it's clearly new that Mr. Gordon is stating that he sold Mr. Puskas cocaine for $40. Nowhere in the prior trial transcript will you hear any reference to Asani Gordon selling drugs to Mr. Puskas for $40, specifically being cocaine. What I will say about defense counsel's statement that he provided on January 14, 2022 in his papers is that this information about what Mr. Warden said at this time obviously gives him credibility. That he says clearly there that the defendant was sick and sweating due to withdrawal from drugs, that the defendant needed drugs and was desperate, and that he recalled that he left out that night because he went out the bathroom and he went to the bathroom and Tim wasn't in the house. Those statements give Mr. Warden credibility that he knew exactly why Mr. Puskas went out that evening. And he knew when he came back, because when he came back, he had $40 to purchase the cocaine on him. That is new information. Your Honor, the state submits that it is motive and intrinsic to this case. And I don't want to continue to argue arguments that we've already presented to you.
Judge, I am not disputing that it is new that Warden now says Puskas handed him $40 to buy cocaine. I'm not disputing that. That is new. I never disputed it. I'm disputing what Gordon says had been told to him by Stecker. Just so the court knows, Mr. Gordon was allowed to testify in the last trial that Puskas was sweating and he was sick. He was allowed to testify to those things. He was also allowed to testify that he saw Stecker give him a sweater that had no hood and no pockets. He was allowed to testify to that because he saw that with his own eyes. But he was not allowed to testify about the fact that Puskas went out to get money. He was allowed to testify that he heard the door open, and when he went downstairs, Tim wasn't in the house. He was allowed to testify about that. That he testified about. But he was not permitted to testify about the information that Stecker told him, which is Stecker believed he went out looking for money to purchase drugs. That's the link. That's the issue. So, without that link, because that link is based on hearsay, Judge Nieves did not allow the drug aspect into this case. I mean, Ms. Desai was on the record telling the judge, I'd love to introduce the fact that he was withdrawing from heroin and he was looking to get drugs, and he went out and he clubbed somebody over the head and took their money. So I'd love to introduce that, but I can't because first, the kid had money on him, he had his wallet, the phone was working, and it's based on hearsay. So, again, the fact that he was sick came in, the fact that he was sweating came in, the fact that he heard the door open, went downstairs, Tim wasn't home, came in. But the rest of it, it cut off because of the hearsay. It's not new evidence. It was discussed ad nauseum. The state attempted every which way to bring that into the case. But they couldn't, and they recognized that.
Your Honor, I want to just respond directly to what the defense counsel just said. It was cut off, if defense counsel is stating correctly, because of hearsay. What the state is submitting is that we're not introducing hearsay on the state. And Mr. Warden told the defendant, told the defense counsel, as well as has already been stated, for Your Honor, in his actual statement that he took from Mr. Warden, that the reason why he did not say about the $40 in the cocaine was because he had his own case pending at the time and did not want to further implicate himself in his own case. So again, Your Honor, not only is the state at this point not intending to seek to admit any hearsay, but there is a reason that easily Mr. Gordon can be cross-examined about as to why he did not say it on a crime.
Once again, I don't think counsel hears me. I am not saying that the act of giving somebody $40 and getting cocaine is not new. I'm not saying that. That is new. That's new. What I'm saying is not new and is hearsay. To get to the $40 is what Wayne said to Gordon. You don't get to the $40 if you can't show that Gordon knew this firsthand, that Puskas told him he's going out to get money so he can buy drugs from him. That's the issue. And what Gordon does is he changes now. Now he says, no, Puskas said this to me when all along before, for years, he said, no, Wayne told me this. Wayne told me this. He didn't just say it on the stand in a 104 hearing that Wayne told him this. He said it to the state's investigators in a meeting with them, private, with his lawyer present, that Wayne told him about this. I'm not disputing that $40 is new. I'm not disputing that. But to get to that, there has to be hearsay.
Your Honor, in the state's paper, it's clear that Mr. Gordon says that Mr. Puskas said that he's going to want to get something of value. Again, it's clearly in the state's paper, no mention of Wayne Stecker telling him he's indicating the defendant told him he's going to get something of value in exchange it for cocaine. That is how we get to him coming back in with the $40 in exchange for cocaine.
So what happens to the first 6 times he said that? It was Wayne who told him this. The court is just going to now believe the last version? That's what I'm saying, is at a minimum, if you're going to allow this in, at a minimum, you have to determine which version is the truth. Is it the fact that Wayne told him this? True? Which then makes it inadmissible. Or is it the fact that the last one out of the 7 versions is true? Which then, if you determine that's the case, then I guess he gets to testify to it.
It seems to me, Mr. Masrani, that if the court previously determined that what was told to Gordon by Stoker doesn't come in, nothing about that changes, right? So it's hearsay out now, right?
It doesn't come in because we objected to it.
Well, and it's hearsay.
Correct.
And so the court has a gatekeeping function, right? To the extent that something is hearsay, it's not coming in. However, the state's argument now is that Gordon, although you may not believe him because all the other times he said it came from Stoker, he is now saying this information was told directly to me from Puskas. And so you get to ask, why didn't you mention this before? You get to ask that.
Judge, again,
Right.
by the very...
And we know that he couldn't because it was hearsay.
By the very nature of the question, you're putting Mr. Puskas's rights, his constitutional rights, in basically he's got to pick, and you're basically taking yourself out of it as a gatekeeper to determine, and I gave you a case which allows you in this very instance to actually listen to the testimony of this person and say, you know what, it's not credible. The first time he said this under oath, second time he said this under oath, the third time he said this under oath, fifth time he said this under oath, and now all of a sudden, and every time he talks about Wayne Stecker, he gets upset because Wayne Stecker is dead. Judge, you have a gatekeeping function. That is a gatekeeping function. You have to determine whether evidence is reliable. You have to determine whether it's based on personal knowledge. And I presented you with ample facts to suggest to you that it's not based on personal knowledge. And you're saying to me, well, just ask the question a different way.
Well, yeah, because at the end of the day, he gives an explanation as to why he may very well have been saying it came from from Stoker, right? He says, I have my own stuff going on, and I wasn't about to put myself in a position where not only are they now charging me with the drugs they found as a result of executing a search warrant, I'm putting myself in a position of being a drug dealer, and so that's a whole nother charge, right? And I'm not going to put myself in that situation by telling you this information. That's the argument.
Your Honor, the thing that you miss out of that argument is I'm not disputing the fact that he's saying, the reason I didn't say I sold him the drugs because I didn't want to get in trouble. I'm not disputing that. What I'm disputing is his knowledge about what Puskas had in his mind, or he claims he had in his mind, right? That's what I'm,
tells you now that it came from
Now.
Puskas.
well, he's saying now it came from Puskas. But before, all along,
I get it.
he said it didn't come from
I
Puskas.
got it. I
So,
understand your argument. We need to move on. I get your argument.
and-
Whether you think I do or not, I do get your argument.
it's more eloquent in the letter we submitted to you, Judge. We
Trust
pay-
me, let me just make something very clear, right? So you ask me questions about whether or not I've read something or not read something. Let's be clear. I read everything that comes across my desk. My law clerk will print it out. It will make its way to me. And before you get any decision from me, you will all know that I have read everything and considered everything and made an informed decision based upon not only what you presented, but my understanding of the law as it applies to the facts as you presented. So nobody would operate under any misperception that I'm not reading what you send me, because trust me, that's not how I operate. So that's out there. Let's move on to the next one.
Thank you. I believe we're going to move on to the jail call, Your Honor. And specifically, the state is seeking to admit a jail call from April 7th, 2014. The call was at 8:56 p.m. The state submits, Your Honor, that this, again, under statement against party opponent, is admissible because it is the defendant's statement made and it is relevant to this case. Specifically, the statement the state is seeking to admit, and we'll play for Your Honor shortly, is the defendant's statement on a call stating, whatever, just stop saying, sometimes I just can't get you to shut the fuck up and say the right thing. You can't be giving them hints towards anything, is what I'm trying to say. You don't have to put actions in. Now, Your Honor, the state is going to play that statement for you now. That's going to be S4. I'm going to
And
play.
just for the record, so this issue was also addressed by Judge Lewis, right?
Yes, Your Honor.
Okay.
This issue was brought up by the state before Judge Neves. The state submits to Your Honor 2 issues with what was previously presented to the previous court. Your Honor, the state first submits that the previous court did not provide an actual ruling. While it is indicated that it was brought up and that the previous court, and I quote, said that it may have been some gumbiness, there was no specific decision as to why or whether it would be admitted, why it would not be admitted, and the reasons for that, a decision, either in writing or on record, that the state was able to locate. And, Your Honor, the state submits that the lack of that decision in itself permits the state to present that to Your Honor, to have a specific ruling on same. In addition to that, Your Honor, the state submits that, and throughout the state's papers, again, the state goes through the law and all, but the point is that the defendant is not at any disadvantage now at this stage where we're at, for the state to present this, to go through the rules, play the actual statement for the court in its entirety, and then have a ruling made. The statement, again, Your Honor, it meets all the requirements based on the rules of evidence as far as statement against party opponent for hearsay, as well as the rules of evidence for relevancy, because it's relevant to the consciousness of guilt theory that the state is submitting to the court. So for those following reasons, Your Honor, while this was previously attempted to be litigated at the prior trial, because there was no decision in regards to the actual reason for the inadmissibility of the actual statement, the state seeks to admit it under the rules of statement against party opponent because it contends it's relevant to the state's case. So at this point, Your Honor, the state is going to play S4, and I'm going to play on S4 section 6 from minute 6:51 to 7:04.
Judge, if I may, before the calls play,
Sure.
answer your question, please. First, I object to the claim of this call at this time. This, I know the state wants to take a picture that it was not litigated at the trial. It was litigated. It was litigated, it was put before Judge Nieves, and Judge Nieves didn't make a rule. Anybody who knows Judge Nieves, and Ms. Gibbs knows Judge Nieves very well, the way he rules is not conventional, but he ruled. He ruled. He didn't write a decision because this was an application made to him right before the state wanted to play the call, or they made him aware we want to play this call the next day. I think we argued it. The state told him what it was, and we fully briefed this in the papers that we submitted, Judge. And Judge Nieves' ruling, if you will, and I'll read it for the record. Quote, "What? That's a stretch of the stretchiest stretch that I've ever, that's Gumby-ish. Are you serious?" That's what Judge Nieves said about that call. So the state keeps saying to you, well, just because a party opponent said that, that means it's admissible. No, because then you got to talk about relevance, and you got to talk about whether 4-3, the balancing act in 4-3. And here, what we have is Mr. Puskas telling his mom to stop talking on a recorded line that he knows is recorded. He has every right to tell anybody that's trying to talk to him about something the police did to shut the fuck up. Because they tell them that it's being recorded. It's being recorded, and we know time and time again, it's used in court, it's used in proceedings, and the Supreme Court finally cleared the way to that on a Fourth Amendment and Fifth Amendment challenge.
I'm taking that you use that language because that you're saying that that's what he would
Yes.
say. Okay.
I'm not,
Yes.
yes.
Yeah. Okay.
It's not very eloquent, but he's trying to get the message across. And we argued in our papers, Judge, it also touches on his right to remain silent. He's telling his mother, I don't want to talk about my case. So what's the state going to argue? Well, he's telling his mother to shut the fuck up because he didn't want to talk about the case, therefore he has something to hide. Because that's the very thing we tell jurors they can't consider. Whether there's some sort of indication or some sort of argument by the state that a person didn't say something or tried to stay quiet because they have something to hide. So, again, fully litigated by an outstanding trial attorney on the state side at the first trial. And Judge Nieves, in his eloquent words, made a ruling. He heard the call. He didn't hear it. I mean, he had the transcript, I think, what we did. It's all in the transcript of that day, Judge.
Your Honor, I just want to start with exactly what the defense counsel ended with. I don't know how a court can make a ruling on something they don't hear. Judge Nieves never heard this call that the state is about to play for Your Honor right now. How do you
You
make...
say you heard it. You say you heard it. You say you didn't hear it.
No, and Judge Nieves says it as well. The court specifically states in the transcript that, but then, okay, the state is trying to play something, and what it is that you're trying to play, because I haven't heard it, right? That's out of the transcript. The state did not have the opportunity to actually play a recording of the defendant, and we're here today because it only lends credence to the state's argument that it was not fully litigated. So there could not be a ruling, and the stretchiest, I bet it was stretchy. The Judge Nieves didn't hear the evidence. So at that point, Your Honor, the state submits that the state is only here now trying to do the complete job of playing it, arguing under the rules. And again, we can hear about a right to silence and so forth. This is the defendant discussing his mother speaking, who has not been charged with anything and nothing to do with it. At this time, I'd like to play the tape, and then after I play the portion, I can argue why, again, it's admissible under the rules and doesn't have any issue to do with the right to remain silent.
So I'm begging you, when you sit down to read the stuff, read the argument that occurred on this before Judge Nieves. We referenced the transcript. I'm begging you. Because the state keeps saying it wasn't played.
You have to beg.
It wasn't played.
You're spending more time arguing over, just play the tape and then I'm going to make a decision.
Judge Nieves was told what was on the tape.
Again, for the record, Your Honor, on S4, the state's going to minute 6. Second. 51.
You know, whatever. God, sometimes I just can't get you to shut up. Say the right thing. You can't be giving them hints worth anything, Mother. That's what I'm trying to say.
Now, Your Honor, that is the entirety that the state is seeking to play from the call from April 7, 2014 at 8:56 p.m. Now, again, Your Honor, the state submits based on the role statement against party opponent that that's the defendant's statement. The state submits that based on relevancy, it is highly relevant to the state's case as far as consciousness of guilt, that when the defendant is speaking to his mother, he says, I just can't get you to shut the fuck up. You can't be giving them hints to anything. Your Honor, this is highly relevant because prior to this phone call, the state seeks to admit through the lead investigation that the defendant's mother's home was the target and had executed a search warrant at the particular house. At that search warrant, the officers were unable, despite a in-depth search, unable to find hints, information, gathering evidence, continuing to try to find something of value to help them in the investigation. Now again, they came out the home with items, but they were seeking certain things, and they were seeking certain items that they were not able to provide. This phone call is subsequent to that, where the defendant states, Mother, I can't get you to shut up, and you can't be giving them hints to anything. The state believes that it is relevant for consciousness of guilt that he did not want any hints to be provided to law enforcement as to his guilt in this particular case. Now, counsel argues that this is not relevant. Again, the state's anything that would lend to the fact that the defendant is either trying to cover up something or not give hints to law enforcement, and frankly, the fact that he would have that kind of disdain towards his mother is all relevant to the state's case. The inflection in his voice, the agitation with hearing that they're possibly giving hints, all is relevant to how he felt when there would be any indication that his mother could have possibly given any hints to law enforcement. Again, Your Honor, the state believes that these statements are relevant, and I don't believe that there is any prejudicial effect, Your Honor, except for the fact that obviously speaking to his mother in that way, it does not seem very kind. But other than that, Your Honor, the state submits that there is no undue prejudice or no reason under 403 that this particular piece of evidence would be excluded. Now, to defense counsel's point about his right to remain silent, again, this has nothing to do with the defendant speaking to the police. This has nothing to do with the police forcing the defendant to speak to him. This has to do with the statement that the defendant made on a recorded line where he knew was being recorded while he was on the phone with his mother, as he indicates, and where he states that she needs to be quiet because he doesn't want her giving hints to law enforcement. So with that, Your Honor, Ms. Steve submits.
Judge, again, a very narrow approach. You don't have to be speaking to the police. The state can't comment on somebody's desire to shut up about their case. They can't comment on somebody's, being intelligent when they know the police are listening to them. And they're trying every which way they can to pin this crime on them to say, shut the fuck up. I mean, that's what we tell our clients. Don't talk on the jail phones, right? And here you have a mom whose son is in jail, which is obviously you would have to tell the jury, right? You admit this, that he's in jail. So now they would know something that's usually we don't tell jurors. So you got this, these check boxes, right? You have unduly prejudicial, misleading, and you have probative value, right? And you go and do the balancing, and you will see, Judge, that those arguments that the state made today are the same arguments that Mr. Sy made in 2016. The same arguments. Oh, he's talking about hints, he must be hiding something. Very speculative. And that was the entire trial last time. Very, very speculative. And the appellate division, in those 70 pages, kept saying and kept going back to the fact that you can't put circumstantial evidence on top of circumstantial evidence on top of circumstantial evidence. You have no evidence. And this is exactly what's happening again. Advancing the idea of this ravenous drug user. Advancing this when somebody's telling their mother, I don't want to talk about the case. Not the most eloquent words. He wasn't being lawyerly. He said, please, mother, I don't want to talk about what the police are doing out there. Or, please don't talk about the case. He's being recorded. Fully litigated.
Judge, I just want to make clear here the state's wording, because I've heard now multiple times today that the state keeps just trying to bring small pieces of evidence and put them all together to try to bring together the horrific events that have happened to the victim here. Your Honor, I submit that is the state's job to do. Your Honor, back in October of 2021, when we first came before Your Honor after this appellate division decision, challenged the state and said, this appellate division has stated certain findings. And with those findings, are you going to be able to represent this case to a jury? So the state went back and reviewed every piece of their discovery that they had, with the obligation and responsibility to look through the evidence and, based on the rules of evidence and the rules of court, come back before Your Honor and present evidence, no matter how big or small it is, to the court for admissibility to be in compliance with the appellate division decision and still present a case to the jury beyond a reasonable doubt. While defense counsel may believe that these are very simple, tiny pieces of evidence that are irrelevant, every piece of evidence that the state is putting before the court, the state submits is relevant to prove the defendant's guilt. They have different reasons, they have different purposes, they have different jobs that they do to prove the state's case. So while this may seem small and while it may seem insignificant to defense, it is highly relevant to the state's case that when confronted with the fact that, again, we don't need to mention that he's in jail. We can simply, as the state stated to Your Honor, mention this call took place after a warrant was executed on his mother's home. And on this call, he says, Mother, I wish you would shut the fuck up and not give them any hints. That's what happened here. That is relevant to the state as far as consciousness of guilt, and the state believes that every piece of evidence that they can put forth that is admissible under the rules of evidence, they will do so in order to prove this case beyond a reasonable doubt. So with that, Your Honor, while others may think it's small pieces of evidence, the state is doing their job here at the state's needs.
I guess the state's not aware that you can't say a warrant was executed on the house. It's case law. Again, you know,
You don't need to repeat yourself, because
I'm not repeating myself, but when the state talks about it's their job, and it's my job to do, it's the state's job to not present a case to a jury where they have doubts about being able to prove it beyond a reasonable doubt. That's their job.
Yes.
Your Honor, the next argument of the state's motion that the state is presenting is the consciousness of guilt evidence. And in its papers, Your Honor, the state goes through three pieces of evidence that we believe are important to the state's case. The first piece of evidence that the state outlines in its papers is the evidence of, again, from the defendant's phone, from admissions to a Kimball Medical Center, and third, a flyer from Mr. Billy McCall, a flyer where Hassan recorded the observations of the defendant. So I'll briefly go through each piece, Your Honor, and then at that point, the state will just argue the case law. Specifically, the first piece is a history that came from the defendant's phone, where he is, there's an origination of the victim's Facebook page, as well as indication that he read a media article in regards to Mr. McCall. Now, Your Honor, that's relevant to the state's case because, again, a photo of the victim being on the defendant's phone, as well as the information about the article. While I understand defense counsel can argue this was an incident that happened up the street from the home, that he was looking for the information in regards to it based just on the facts that this was a homicide that happened up the street. Your Honor, the state submits that based on the fact that not only was there a post that went to Mr. McCall's Facebook page, in addition to the fact that they were, that there was also the media article, the state would submit, Your Honor, that does give some indication of a consciousness of guilt. The searching of this individual, looking into discovering the individual who he had attacked that night, discovering that the person had died and was murdered that night. Again, Your Honor, all are indicative of the actions that occur after the fact in the consciousness of guilt. Second, Your Honor, the state is submitting that the defendant's statements to his sister in regards to saying he can't take it anymore and crying before her as she drove him down to the Kimball Medical Center, which is a mental health facility located in Lakewood, New Jersey, that was an indication again of a remorse or consciousness of guilt based on an incident that occurred within days, 2 days prior to the actual murder of Billy McCall. Your Honor, there is case law that clearly goes through that this kind of behavior is indicative of consciousness of guilt. The state has cited State v. Mann, State v. Mills, and I'll get into State v. Mills momentarily when I go to the third piece, Your Honor, which is the roommate, again, Hassani Gordon, observing the defendant looking at the flyer, which was an information flyer included in the state's submission of William McCall, giving information about the victim and as well about the incident where it occurred. Specifically, Mr. Gordon states that he observed the defendant staring at the flyer to a point where it made Gordon uncomfortable, that it was an act that he believed was more than just something of feeling bad that the young man had been murdered, but that it was some inflection, some over remorseful behavior. And the reason why the state submits that that is significant, Your Honor, is because based on Mills, that court also found that the defendant going to the gravesite of children that were murdered in a home when he had no relationship to the children at all and just happened to be a gas attendant across the street, had no relation to the point of the act of remorse that he was displaying at crying at the grave sites of the children. Your Honor, there's also a case that also specifies that the attempted suicide attempts of the individual in a particular case also indicates a consciousness of guilt. But either way, Your Honor, the state has outlined in the motion for consciousness of guilt the three pieces of evidence and the law as to the admissibility of saying and why they would support the consciousness of guilt. So again, Your Honor, I do understand that while the defendant has objected to these pieces of evidence, the state submissions are relevant to consciousness. Thank you.
So one question, you acknowledge that, and I'm talking specifically now about the evidence that you seek to admit regarding the statements to the sister and the defendant having been admitted to a psychiatric facility. You would concede that he had other stuff going on, right? So he had other charges. So there were other issues that the jury could never know about, right?
100%, Your Honor. 100%. And I will say to that point, Your Honor, the reason why it's specific here is he did have other things going on. However, I do believe, again, the state submitting to you based on the evidence, that after the search on February 17th of 2014 and seeing that the individual that he had bludgeoned to death over taking money had been murdered, he had killed him, that in fact was what made him say, I can't take it anymore, and want to be taken to the facility. Do I believe that at that facility, not only did he want treatment for suicide, but also treatment for drug use and so forth? Yes, I believe that that was the final straw that the defendant felt, that his violent act against another person, he was completely out of control and wanted to seek help. So while I agree that he had other things going on that the jury should not hear about, I still submit to the court that it was the murder of Billy McCall and the recognition of same based on the searches and the information that the defendant found was the final straw in what sent him to the Kimball facility. Now, it is clear based on the discovery that Kimball did not accept the defendant because he also wanted drug treatment. And they were not a drug treatment facility, they were only a psychiatric facility. So as submitted in the State Exhibit 1 contained in that particular motion, the intake was for 0 days because once he went to the facility and it was not a drug facility, they were not able to treat him at the facility for the dual issue of the psychiatric as well as the issue.
I guess counsel neglected to mention that the flyers were out long before 217, indicating that the young man had passed. The article was out, I think, that day. I looked at the article, and I'm sure hundreds and thousands of people did. I guess I'm a suspect. These arguments are absolutely preposterous. Preposterous. For the same reason that question you asked, the jury can't know about those things because they're just so inadmissible. Brings me back to the argument that I told you about before. Now that Gordon changed his statement, they can't know about all the hearsay that he developed from Wayne Stecker. It's the same issue. What does the state do? What do they give you? They tell you that a person who lives up the street looked on their phone, which is something we all do, an innocent thing. And they want to take that innocent thing and argue to the jury that he looked on his phone, therefore he's exhibiting consciousness of guilt. They want to take, and it's funny how Gordon, I don't know if you did that, obviously you will, you'll see Gordon's statement, and the detectives keep asking him, well, what did he say? What was he doing when he was looking at the flyer? And Gordon kept repeating. He just kept saying, I can't believe this has happened. I can't believe this happened this close to home. I can't believe this is happening. Normal reactions, but Gordon develops this cloud of suspicion because Tim Puskas is looking at the flyer. A bunch of junkies in a house, every one of them nodding off on drugs. Gordon, Stecker, Sporacco, Puskas, Harpster, Edwards. It was a drug house. And we don't do heroin, Judge. But I suspect a person is shooting up 30 to 40 bags a day with a needle in their arm, and they're zoned out, and there's a piece of paper in front of them. I suspect they'll probably be looking pretty weird to another junkie who's looking at them looking at a flyer, right? But no, we're not going to tell the jury that. What am I going to get in front of the jury, ladies and gentlemen? He was nodding off because he had just used 40 bags of heroin. And this is how preposterous this case is. And all the state keeps saying, oh, what a horrific act. Of course it's a horrific act. Do your job, find out who did it. Don't just try to, say, oh, the person looked at an article, so therefore they must be guilty. Or you know what? I have a better idea. Get the medical records from Kimball. Don't present a zero admission date. I mean, isn't that something we would do? Shouldn't there be medical records where he was evaluated? Won't we want to see what he said? Don't we want to know? His mother was dying of cancer. He was charged in a vehicular homicide. He was doing 30 to 40 bags a day of heroin. His junkie friends were stealing his money. And then because he tells his sister, I can't take it anymore, therefore that's evidence that he bludgeoned somebody to death. But no, we don't get the records. We're just gonna present the court with this cloud of speculation and ask the court, please give us this little piece of evidence and that piece of evidence and this piece of evidence so we can argue to the jury that this guy is a monster and he knows how to, a junkie monster who knows, I guess, how to hide all the trace evidence from the most, probably the bloodiest murder I've ever done, and I've done quite a few. Trace evidence doesn't get hidden that way. It just doesn't. It doesn't disappear. So, oh, I forgot, Judge, all these things were litigated in the prior trial. And Judge Nieves said, no drugs, no withdrawals, no Kimball Medical Center. This motion was filed. This motion was filed. Thank you.
Your Honor, I just want to, there was never, I did not see any litigation as to the flyer, staring at the flyer and the flyer litigation. That was information that was provided to the state, I believe, October 20th. I did not see that presented to Judge Nieves, but I can indicate from the record that yes, defendant's admission to what Kimball Medical Center was, as well as another admission that he had subsequent to this, which again followed another attack. So those are the only issues that were submitted as far as the state was aware, and obviously the defense counsel has a different recollection.
I have to be candid with the court, Judge. Because I don't like not being candid. It's clear to me that the state did not read the transcripts because the flyer issue was litigated and Judge Nieves allowed the testimony. He also allowed counter testimony by Mr. Gordon's girlfriend, who saw the same thing. And she told a very different story than what Mr. Gordon said. So that testimony was allowed. The fact that Mr. Puskas looked at his phone, or the fact that they looked at Mr. Puskas' phone and they saw that he had looked at an article from Mr. McCall and that he looked at his Facebook page, that was also argued, and Judge Nieves allowed that. So it's in the transcripts, Judge. I know it's a lot, but it's there. Those were admitted, and obviously with their explanations. Obviously, I'm now objecting to those now as well, because as I objected back then, I just placed my objection on the record how they're not relevant, innocent facts that anybody engaged in. The Kimball Medical Center stuff, that was denied. And the comments to the sister, I can't take it anymore, and her taking him down to Kimball, that was also denied. I just don't think the state can give you one sheet of paper that has 0 days on it and say the guy was suicidal on the 17th because he bludgeoned somebody to death. They didn't even make an effort to get the records. It's been 8 years. Get the records. How do you know he wasn't there before the 17th? How do you know he hadn't been going to Kimball? How do you know he didn't go to Kimball afterwards too? No, we're just gonna say, he's suicidal because he killed somebody.
Let's move on. Is there a video that you need me to take a look at as well?
Yes, Your Honor, there are multiple surveillance videos. I don't know how Your Honor wants to proceed. I know that it's new now. The state has approximately 24 videos that we need to show Your Honor. There are 2 the surveillance video motion is the last motion that the state has. And the surveillance video motion, while at least the way the state understands it, defense counsel is contesting 2 specific areas, 210 Hamilton Street as well as 78 Easton Avenue, for 2 different reasons. Authenticity as well as relevancy and just basically the fact that the quality of the video is poor. However, Your Honor, the state believes that in order for Your Honor to understand the importance of those videos, the state needs to play the entirety of the progression that the state submits, how Mr. McCall traveled and how Mr. Puskas traveled. That is important to understanding why those videos are important and relevant to the state's case. And as far as authenticity, again, they meet the requirement of the rule as far as being authenticated. So with that, Your Honor, I do have Detective Epstein here. However, if you want to have a break, I do believe it's going to take us at least an hour to get through the videos.
Get it started and then break into a plan.
Okay, that's
Judge,
fine.
if I may address,
Yes.
I just want you to be aware of several things. always been our position from back then, that our objections were very pointed to certain videos, certain clips. Again, I don't stand before you and just shoot from the hip. If, just like I just told you, Judge, those two things were ruled in the state's favor in the first trial. You know, something the state didn't even bring to your attention because they thought they just developed it on October 20th. I'm going to say this to you. We're not disputing all the videos, right? There are certain videos that are highly probative, and if they're properly authenticated, the jury should have them. There are other things you should know. The last time Detective Epstein testified in a 104 hearing, and I just want you to know this, his testimony lasted 5 days. Okay? Because what happened back then is that the state attempted to qualify him as an expert. And because they wanted him to offer opinions about the track of these two people. One they called Billy McCall, and the other they called Tim Puskas. And ultimately, Judge Nieves said, no, you can't testify as an expert for a whole host of reasons. One of the reasons being the way that the video was collected, you hadn't had your training yet, and you can't be qualified as an expert because there's a lot.
Make sure we're not arguing about something that is not necessarily disputed.
And that's why I'm bringing this out. I want to know what parameters you're setting, so I know what.
So it's difficult for me to make these decisions in a vacuum because I wasn't the trial judge. So I'm hearing from the state that in order for you to make any kind of ruling, and correct me if I'm wrong, you need to see all 24 of these in order to understand what you're ruling on. And you seem to suggest that there are some of them that you have no issue with, the jury should properly see them, but I suppose the counter from the state is that, yeah, but you need to see all of them in order to understand where the other ones fit.
So
I don't know what the answer is,
well,
because I wasn't the trial judge.
I understand, and that's why I'm trying to explain what our position was. And if I may, and if the state, maybe the state agrees, maybe the state doesn't agree. It's up to them. But
I mean, I wish you guys would talk to one
you know,
another, and then maybe you can narrow this down, right?
the issue, I'd love to, Judge, but you know, the state is very ingrained in this position that the young man took one track only, and the suspect, who they believe is Mr. Puskas, took one track and one track only, and ultimately they converged on this one street. So, do you need to see all the videos? I don't believe you do. And if I may, if I may, maybe we can save some time.
All of this is going to mean nothing if I really do need to see.
Well, let me, look, I can try if you want me to. This is a map of the area that was introduced into evidence in the first trial.
Can we mark that as an exhibit just so the record knows?
Sure. We can mark it as D1, Judge. Okay. Is there a stick?
Yes, you want one?
A stick, yeah.
Oh, a stick?
Or a
You want a
pointer.
stand?
Oh, you got that. Oh, that's pretty.
I'll get you a stick too.
Stick. All right. So, Judge, it is not disputed that the young man, Mr. McCall, was at a party at 18 College Avenue. He is clearly on video there. He's been identified by his friends as being there. You can see what he's wearing. You can see a bandana on his head. No question, no issues. He tries to get into a vehicle there. He can't. Then he goes walking. He's walking to go somewhere. We don't know where he's going. He cuts through a little alleyway. We don't see him on video when he cuts through the alleyway. He appears on video on cameras run by Rutgers, the University of Rutgers. At this corner here where I'm pointing, which is Condit Street and Eastern Avenue. Okay? Then he crosses the street and comes over to the side of the even numbers of Eastern Avenue, and we see him again under a camera at 66 Eastern. That's the Golden Rail camera. Am I clear so far?
It might just be better for me to watch these videos, because your narrating is not helping truthfully.
Somebody's going to narrate this for you too, but I just want to tell you a couple more things. The state says the next time they see him on camera is on a camera that's located at the corner of Eastern Avenue and Hamilton, pointed in the direction of 140 Hamilton Street. There is no coverage of him walking around this corner, the corner of Eastern Avenue and Hamilton. There's no cameras that show that. There were cameras in the area up Eastern Avenue and down Hamilton Street. The state did not recover those because they made a decision very early back then that he had to have taken Hamilton Street because he ended up on Hartwell. So we don't see any surveillance from this corner, so we don't know if he went straight on Eastern Avenue. We don't know if he got into a vehicle here. We don't know if he made a right on Hamilton Street. We just don't know. Another point of interest is his vehicle was parked on Gilden Street. So even if we can show that he made a left on Hamilton, we don't know if he made a right on Gilden, where his vehicle was parked. It was parked at 15 Gilden. Ultimately, he is found where number 2 is on Hartwell Street, ultimately. And the state's entire theory has been that while he begins his walk from 18 College Avenue, the suspect, aka Mr. Puskas, leaves his home on Plum Street, comes up to Hamilton, makes a left, goes down to Lewis Street, turns back around. We don't know where he goes when he turns around. And then we have a far shot of 2 people. We don't know who they are. The state says they're Puskas and McCall, converging on Hartwell Street, where you see 2 people going down Hartwell Street. That's the case. So I am disputing the Eastern Avenue video, the 78 Eastern, and I'm disputing that clip because we don't know which way it went. As you can see, Hartwell Street's here. There's many ways to get to Hartwell. Okay? And I'm disputing the 210 camera, the 210 Hamilton camera, where it shows this really far shot and 2 sets of legs, if you will, conversion. That's it. So you can decide, Judge, whether you want to begin by watching those clips, whether you want to see the whole thing, what's the scope of the testimony.
At the end of the day, you understand what you're trying to do, present what you feel I need in order for me to make a decision ultimately. Do you need time to set up?
Judge, I don't look for time to set up and I don't ask for 12:30, but I do just want to end it at this. What defense counsel said, everything that you've just gone through, is wonderful for opposing argument. The bottom line is we're here today about admissibility of evidence. That's why we're here. The state submits that the video surveillance all the video surveillance that they pulled has been authenticated and is relevant to the state's case. 210 and 210 Hamilton and 78 Eastern Avenue as well. That's what we're here for today, admissibility. The state wouldn't need to show one video to Your Honor, because the reality is the videos have authenticated in the previous trial, can be authenticated in this trial, and they are irrelevant because they are from the time, place, and area of where the call was at prior and where he was ultimately found. The state submits that the defendant was on the videos at a particular portion, and we're using all those videos to present the state's case. At that point, Your Honor, the state believes, based on the authenticity rule as well as on relevancy, they should be admitted. So if defense counsel is stating that he believes the quality is poor, an argument that he can't see something, or he didn't pull something, or didn't do something, that, Your Honor, goes to weight of the evidence, not reasonable. So with that, Your Honor, the state would just submit that we can put the witness on this afternoon. However, if we're just going to whether or not the evidence the state collected is good or not good, clean or not,
I
the
would
state
appreciate that if you could talk and you could narrow this down in any way, do so. If you can't, it is what it is. I just work here and I show up when they tell me to. Let me just walk off.
I'll talk to counsel.
Please.
I don't have a problem with that.
Please, let me just take 10 minutes, I need it.